Hi, my name is Jim Dillon. I'm a partner at Foley Hoag in Boston, Massachusetts. I specialize in product liability, and I've dealt substantially with the preemption issues that I'll be talking about here. Preemption comes from the Supremacy Clause, and that federal law governs over all state law. In essence, what it means is that once there is a federal law, a state can't require what the federal law prohibits. State can't prohibit what the federal law requires. Let me talk about the case of Reigel versus Medtronic, which the Supreme Court decided in 2008. This was a case decided 8-1 by the Supreme Court that held medical devices that were approved under the pre-market approval plan by the FDA, a very rigorous approval process by the FDA, were so specific in their federal requirements that essentially no state tort law claims which could add a different or additional requirement to those FDA requirements could proceed. All of the state law claims seeking damages from Medtronic were preempted. The Reigel case has its significant follow-on in a case that was decided in January of 2009, also involving Medtronic, involving leads for their medical heart devices. In this case, again, a whole series of product liability cases brought under state law were held to be preempted. And it's significant in a couple of ways. In one sense, it is compelled, as it were, by the Reigel decision in 2008 by the Supreme Court. But that's only in part, because while the Reigel decision really addressed issues about warnings and particular indications which are in the labeling, this case, the Fidelis lead case, really addressed, in addition, allegations about manufacturing flaws. In other words, that these were things that were not specifically dictated by the FDA, but the FDA had in fact given over a category of information and decisions to the company as to how they were going to manufacture it, as to what metals they were going to use, as to what kind of welds they were going to use. And that was in fact held to be preempted, even though there was no literal FDA prescription about this, only an FDA approval of what the companies had submitted. This is really important because it is already becoming a lead ground in discussions in Congress about what to be done about preemption. The plaintiffs' bar and some commentators, in fact, think that this most recent case in 2009 went past what the Supreme Court had done in 2008 and really holds not so much on a conflict preemption, which is what Reigel was really about, but instead focuses on the literal words of the 1976 medical device amendments that, in which Congress said that no state requirement in addition to or different from a federal requirement could be allowed. So this is a case that is at the heart of the controversy in Congress. Well, in 2008, there were bills introduced by Congressman Pallone from New Jersey to deal and address directly the Reigel case. Understand that there's also issues of preemption about pharmaceutical products, which were argued in 2008 but it's not yet decided in the Wyeth v. Levine case. So the Pallone proposed statute addressed, I think, not merely medical devices but also pharmaceuticals. Now, it was introduced in 2008 to make clear that Congress did not intend that state tort law claims were preempted. But since it wasn't enacted, it would have to be reintroduced in this Congress. And there is plenty of indication that Congressman Waxman and the subcommittee chair, the Subcommittee on Health chair, Congressman Pallone, will in fact introduce such legislation this year. Now, understand that there is a lot going on in Congress. The economy is issue number one. Healthcare reform would probably be issue number 2 that they'll be addressing. But there are FDA issues that are going to come into play, and those FDA issues, after they get themselves a new commissioner and get themselves a budget, will almost certainly include some congressional attempt to undo the decision in Reigel and to restore what at least those congressmen believe is the state of play that existed before that, which is that state tort law and the FDA regulation coexisted.